Red and blue lights in your mirror. You pull over and wait. The officer walks up, window goes down, and in the next 60 seconds, most drivers say one of 5 things that hands law enforcement exactly what they need to extend the stop: justify a search or build a case. 2026 changed what those 5 phrases cost you. New court rulings, new state statutes. The legal consequences are categorically worse than a year ago. I'm going to show you all 5, why each one is more dangerous now, and the exact words that protect you instead. Stay through all 5, because the 5th one closes a trap the first 4 open. Why it matters now. 3 things shifted in the traffic stop legal landscape heading into 2026. First, a unanimous Supreme Court decision in May 2026, known as Barnes v. Felix, established that courts must assess the totality of the circumstances across an entire stop, not a single isolated moment. Every word you say from the second you pull over is now absorbed into that full legal analysis. Second, Florida and Tennessee passed sweeping new laws that turned decisions once handled as administrative matters into criminal offenses. Third, federal appellate courts entering 2026 confirmed that drivers who voluntarily provide specific information hand officers the articulable facts needed to extend a stop lawfully under Fourth Amendment standards. The 5 things in this video are not here because they were always bad ideas. They are here because what follows them legally in 2026 is categorically more severe than before. Stay calm through every point in this video. All 5 build on each other, and missing anyone leaves a legal gap that prosecutors will find and use. Thing 1. The first thing is telling an officer where you just came from. The exchange sounds completely routine. Officer asks where you are coming from. Driver names a street, a neighborhood, a friend's address. That answer sounds cooperative. Courts are treating it differently now. In August 2026, the 8th Circuit decided United States v. Miller. A Kansas City driver was stopped for a broken headlight. He voluntarily told the officer where he had just come from. The officer recognized that location as an area flagged repeatedly for drug activity and known trafficking operations. That single statement, freely given without any legal obligation, became the articulable fact justifying extending the stop into a full drug investigation. The driver built the officer's legal case with his own words. Body camera captured every syllable. Miller confirmed what courts had previously disputed. When a driver volunteers a point of origin that an experienced officer connects to known criminal activity, that statement alone can justify extending the stop. You cannot know which addresses, bars, or parking lots are in any law enforcement database. Once it is on body cam, it is evidence. There is no way to unsay it. Stay calm. When the origin question comes, your response is this: I invoke my right to remain silent. That closes the door that a location answer permanently opens. Thing 2. The second thing is admitting you are nervous. It seems like relatable honesty. Officers are trained to document it as a behavioral admission. Before May 2026, nervousness was frequently challenged in court as an insufficient basis to extend a stop. The 8th Circuit had held that nervousness and inconsistent statements alone did not justify a search. Courts across the country had repeatedly ruled, nervousness is not reasonable suspicion by itself. Then Barnes v. Felix changed the analytical framework at the Supreme Court level. The court ruled that courts must evaluate the totality of the circumstances, meaning nervousness does not need to be the only factor. It just needs to be one articulable fact among others. Prosecutors stack it. A driver who admits nervousness, named a flagged origin location, and has an air freshener visible, has handed an officer 3 separate articulable facts, each insufficient in isolation, but together legally significant under the totality standard. Your admission is on body camera and in the officer's report. If you say you are always nervous around police, that sentence becomes part of the documented totality every court must now weigh under Barnes v. Felix. Stay calm. Stay controlled. Never narrate your emotional state on camera. The counter is the same phrase. I invoke my right to remain silent. Thing 3. The third thing became legally dangerous overnight. That is not an exaggeration. The statute changed on a specific date. It is saying you only had 1 or 2 drinks. Picture this. Officer stops you, leans toward the window, and asks if you have been drinking. Driver says, "Just 1 beer with dinner, officer," about 2 hours ago. That sentence, documented on body camera, activated a legal sequence that is now harder to escape than at any prior point in the last decade. In Florida, starting October 1st, 2026, under a law known as Trenton's Law, any admission of alcohol consumption during a DUI investigation triggers an investigative path where refusing chemical testing is no longer just a civil administrative penalty. Before October 2026, refusing a breath test in Florida cost you a license suspension. After October 2026, that same refusal is a second-degree misdemeanor, carrying up to 60 days in jail and a permanent criminal record. Tennessee compounded this starting January 1st, 2026, raising first-time refusal suspensions to 18 months and expanding admissible testing to include oral fluid samples. The trap: you admitted the drink to seem cooperative. That admission is documented on body cam. It gives the officer documented probable cause to investigate further. You then face a choice that carries criminal consequences. A decision from a year ago did not. The phrase that closes this before it opens: "I invoke my right to remain silent." Nothing about what you consumed. Nothing about when. Silence and an attorney. That is your legal shield in 2026. Thing 4. The fourth thing is describing your travel plans when the account contains any imprecision. This one is subtle, and that is exactly the danger. Officer asks where you are headed. Driver says home. Officer asks where from. Driver says a friend's place. Officer asks how long you were there. Driver estimates maybe 3 hours or so. That estimate is now a documented fact. The 8th Circuit and the 4th Circuit, both in rulings from the past year, addressed stop extensions based on drivers giving travel accounts officers characterized as vague, inconsistent, or implausible given the route. In one 2026 case examined in Federal Law Enforcement Training Resources, a driver's admission that his rental period did not match his described travel plans became a factor courts upheld as reasonable suspicion for extension. You cannot know which of your answers creates what an officer calls an inconsistency. Your memory of timing is imperfect under roadside pressure. Their training is specifically designed to locate those gaps. And once inconsistency is flagged on body cam and documented in a report, courts entering 2026 upheld that combination as justifying a full stop extension and consent request. The Virginia Supreme Court in 2026 confirmed that consent requests during an incomplete stop are not improper extensions. Your imprecise travel narrative is what makes the stop incomplete. Stay calm. Do not describe your route or estimate your timing. The phrase is 4 words. I invoke my right to remain silent. Thing 5. The 5th thing makes the other 4 permanent. It is saying anything that signals cooperation when an officer asks to search your vehicle. Go ahead. I do not mind. I have nothing to hide. I guess so. Any one of those phrases, captured on body camera, is legally operative consent. It eliminates the Fourth Amendment challenge your attorney might otherwise have filed. And subscribe right now so you never miss a legal update like this one, because what follows is the mechanism that closes the trap the other 4 opened. In 2026, the Virginia Supreme Court in Commonwealth versus Nightwalker confirmed that asking for consent during an ongoing incomplete stop is not an improper extension. That ruling means this: if you have handed them a flagged location, admitted nervousness, confirmed a drink, and given a travel account with gaps, they can legally ask to search. And if you say anything that sounds like yes, every piece of evidence found is admissible. Nothing about what came before it changes that outcome. This is where all 5 things compound and become irreversible in a single stop. Consent seals the case before your attorney can open it. Body cameras capture this phrase more consistently than any other exchange at a traffic stop. The exact words that prevent it: I do not consent to any searches. Clear, audible, on camera, every single time they ask. The compound effect? Here is what the 2026 legal picture looks like when a driver says all 5 things in one stop. They named their location. That created an articulable fact, confirmed viable under 2026 case law. They admitted nervousness. That added to the totality of circumstances Barnes versus Felix requires every court to weigh. They confirmed a drink. That activated a DUI investigative path under state laws harsher than 12 months ago. They described a travel narrative with gaps. That gave the officer documented grounds to extend the stop under recent appellate rulings entering 2026. Then they consented to a search. That erased the Fourth Amendment challenge before it could be filed. 5 statements, 1 stop. Every statement reinforces every other under the totality standard. A prosecutor reviewing that body cam sees a driver who placed themselves at a flagged location, admitted anxiety, acknowledged alcohol, gave a vague account, and then consented. That is not isolated mistakes. That is a complete legal narrative built entirely from the driver's own words. Stay calm. Provide your license, registration, and insurance. When questions begin, I invoke my right to remain silent. State watch. Before we close, specific state exceptions matter here. In Florida, as of October 2026, a first-time breath test refusal is a second-degree misdemeanor with potential jail time and a criminal record, separate from the license suspension. In Tennessee, starting January 2026, first-time refusals carry an 18-month suspension, and oral fluid tests are now admissible, expanding what prosecutors can introduce. In Ohio, the 2026 Supreme Court ruling in State v. Phipps confirmed that officers can extend a stop on newly developed reasonable suspicion even after the original basis dissolves, meaning any statement you make mid-stop is more legally exposed than before. In Virginia, Commonwealth v. Nightwalker confirmed that consent requests during an ongoing stop are not improper extensions. If you drive in any of these 4 states, every one of the 5 things in this video carries materially higher legal risk than the national baseline. Verify current law with a local attorney before relying on any of this in your specific situation. The shield. Core principle. In 2026, every voluntary statement you make at a traffic stop is a legally usable fact that gets combined with every other statement under the totality standard 5 Supreme Court justices unanimously affirmed in Barnes versus Felix. The 4 phrases that protect you across every scenario in this video, "Am I free to leave?" sets the legal status of the encounter. "I invoke my right to remain silent," closes every question about location, destination, anxiety, and what you consumed. "I want an attorney," ends investigative questioning immediately and unconditionally. "I do not consent to any searches," preserves the Fourth Amendment argument before consent can erase it forever. Write those down and practice them before you ever need them at a stop. This is educational content only, not legal advice. Always consult a qualified attorney in your state for your specific situation. If this helped you understand what changed and why it matters in 2026, like this video and hit the bell so new legal updates reach you the moment they drop. Subscribe to stay legally prepared, not legally exposed, at every stop. The next video builds on this constitutional framework with protections that work at a completely different standard. It is on screen right now. Drop me a comment telling me which of these 5 surprised you most and where you are watching from. Hype this video if every driver on the road needs to know what changed before their next stop. The law has already shifted. Now you know exactly where.